In this video, we'll discuss union contracts and their administration in the workplace. Contract administration is really just the day-to-day enforcement and interpretation of the contract. This is a critical process in U.S. labor relations and involves rights disputes. Remember, rights disputes are disagreements over the rights that somebody has under the contract. One party or another may believe that the contract offers them particular rights or protections, and the other party may disagree. This relies heavily on past practices. What have the company or the employees done in the past? Contracts are important for workplace justice and efficiency. Workplace justice and efficiency are best achieved through written workplace rules enforced by a private system of workplace dispute resolution. So this is why our grievance procedure is so important. U.S. union contracts. Workers have fought for workplace justice in the early decades of the 1900s. What they were attempting to do was to try to force employers to follow impartial rules. So they wanted things like wages based on jobs rather than unfair manipulation of piece rates. They wanted fair treatment in the workplace. They wanted things like promotions and layoffs to be based on seniority rather than managerial favoritism and discrimination. Remember, we talked early on about how managers may behave in a very paternalistic fashion and not treat the workers fairly. Workers fought hard against that and attempted to create these contracts. These contracts are a way of introducing civil rights into the workplace, requiring management to be conducted by rule rather than by arbitrary decision. Today, union contracts are considered legally enforceable documents. They specify the laws of the workplace in great detail. If you pick up a union contract today, these will easily be 200 to 300 pages. Most contracts have a duration of 3 years, as we've discussed before. Some contracts include a reopener clause, which means that we can reopen negotiations if there's something that's changed significantly and the parties feel like they need to sit down and renegotiate a contract inside the term of the contract. Most contracts are not renegotiated until the contract is reaching expiration. So what kinds of things can we find in a contract? U.S. union contracts will include both rights and obligations. So you can see here employees' rights, but also employees' obligations, and similarly for jobs and unions. Employees have the right for just cause discipline and discharge. They have seniority rights for layoffs, promotions, and the like. Employees have the right to certain compensations, benefits, call-in pay, wage increases, and so on, and fair hearing through the grievance procedure. But employees also have obligations. They must obey the work rules. They must follow their supervisor's orders, and they need to abide by the contract. If we go to arbitration, they must accept the arbitrator's awards. There are also certain job rights. So job holders are entitled to a certain wage rate. These job rights also include specific tasks that must be done within the bargaining unit and by certain jobs. Remember, we talked about being able to go out on strike if work that was supposed to be done in the bargaining unit was being done by somebody outside of the bargaining unit. That's a job right. Those specific tasks are supposed to be done by a specific job title. This is one of the rights of the job. But those folks doing those jobs also have the obligation to fulfill their job standards. So if they're not meeting the criteria of the job, they are in violation of the contract. The union also has rights. The union has the right to be the exclusive bargaining agent. The union leader has access to the workplace. The union can have a place to post in the workplace for workers to read. The workers can have access to shop stewards. The shop stewards are there to hear their grievances and take them up the chain if they're severe enough to determine additional process is needed. And the unions have right to union security and dues. The union has obligations, though. They must abide by the contract, including not striking over grievances, which is an important concern. And the union also must accept the arbitrator's award should a grievance go to arbitration. The goal of these things are to avoid favoritism, manipulation, and abuse. Unions are much more likely to get good benefits and pay relative to non-union situations. And the grievance procedure that's designed typically in these contracts entitles workers to challenge the bosses if they feel their rights are violated. These clauses also typically limit subcontracting, and they grant the union the right to be recognized if a company is to be sold to a successor company. So we talked about unions having a security clause in the contract where the union is the sole representative of the employees. There are several types of union security clauses. You can have a closed shop. This requires the employer to hire only union members. You can have a union shop. A union shop requires all employees that qualify to become union members after they're hired in order to keep the job. And you can have an agency shop. This requires employees to pay union dues after they're hired in order to keep their job. The National Labor Relations Act outlaws the closed shop. In states that have right-to-work laws, which is about 22 states, these outlaw union shops and agency shops. In other words, workers have the right to work the job, but are not required to become a member of a union or pay union dues to have the job. However, in the 28 states that do not have right-to-work laws, unions are allowed to negotiate union or agency shop provisions into the contract. And remember, employees of a company can petition the National Labor Relations Board to hold a special deauthorization vote in which employees can vote to revoke a union shop clause. So the workers can decide they want to vote out the union. Another important piece of the union rights and obligations is something called Becks Rights. Becks Rights are the right to pay less than full union dues. So some people who work in a company that requires them to join a union are not interested in being a member of the union. These workers need to only pay the amount of dues that go toward collective bargaining and contract administration. The National Labor Relations Board has ruled that organizing expenses for employees in the same competitive market are also allowed. The courts have not allowed general organizing expenses. And in fact, just 2 years ago, the Supreme Court actually came back to say that workers do not even need to pay the dues associated with the collective bargaining and contract administration. So this 1988 ruling from the Supreme Court called Becks Rights has actually been extended further to say that workers do not even have to pay the dues associated with collective bargaining. Other components that go into a contract. This is on the management side and on the grievance procedure. Management has certain rights. They have the right to hire and fire with just cause. They have the right to determine what job content will be and how big the workforce will be. How many workers will they hire? They have the right to establish how production will be carried out and what the rules of conduct are. They decide those economic questions of what to produce and how and where to make it. But management also has obligations. They have to abide by the contract, including not making unilateral changes to the contract. They must engage only in just cause discipline and discharge. They have to maintain safety standards, and like all the other parties, they're required to accept the arbitrator's awards. There's nearly always a grievance procedure in the contract also. Employees, the union, and management meet to resolve disputes over the application and enforcement of the contract. A grievance really is we disagree with how the contract is being interpreted or carried out. There's typically a multi-step process here, which we'll talk a little bit further about in a moment, in which unresolved grievances are appealed to higher levels in the organization and potentially to an external party. Other stipulations that we already talked about with regard to union contracts are considered legally enforceable and typically are several years in duration. The grievance procedure is a really important process that we need to talk about. This is the method for resolving disputes and grievances over the interpretation, application, and enforcement of union contracts in U.S. labor relations. This is typically negotiated into the contract. The idea of a grievance process is to offer a balanced dispute resolution procedure for grievances, where workers and workplace justice are not at the mercy of employers and the market. In other words, to ensure due process in the workplace. There's a common phrase about disputes that occur in the workplace. This goes, quote, management acts and the union grieves, end quote. The grievance procedure follows the steps on the screen here. The first step typically is a discussion between the employee who has the grievance with his or her supervisor. So it may be the case that I don't agree with how something's being carried out in the workplace. I go directly to my supervisor and I tell them I have an issue. If it is not resolved at that step, a union representative, typically the shop steward, will then meet with a management official from the employee's department to try to settle the dispute. Often the disputes are settled at this level. If one party or the other is not happy with the outcome of this step, they can appeal further the results of the settlement. This will involve higher levels of both management and the union representation. If the workers are not happy at this point, they can then appeal that resolution to binding arbitration. Binding arbitration, remember, is having a third party tell the company, the union, and the employee what the terms are. So grievance arbitration is really rights arbitration. This ensures that the grievance process is fair and respects workers' rights. This involves a hearing before a third-party, neutral person, the arbitrator, who issues a decision that is binding on both parties. The focus of grievance arbitration is on rights disputes. Nearly all contracts in both private and public sectors include binding rights arbitrations as the last step of the grievance procedure. If the two parties are not able to come to an agreement on their own at any level of employee management interaction, a third-party arbitrator can impose a solution on them. Thanks for watching, and I'll see you again soon.